they can take your house.
And then you find yourself in foreclosure.
And most people don't even know this law exists until it's too late.
On a fateful day, armed U.S. Marshals forced Benny Coleman, a 76-year-old veteran, off his property and kicked him to the curb. Mr. Coleman sat in a folding lawn chair across the street, witnessing the contents of his home emptied. People he has never seen before were carting away his cherished belongings, including his Marine Corps medals and photographs of his late wife Martha. And then, just as they showed up, they changed the locks and they were gone. The duplex in northern Washington, purchased with cash by Mr. Coleman 2 decades prior, stood empty and shattered, leaving the veteran with nowhere to go. Feeling confused and lost, Mr. Coleman situated himself on the front porch of his property and for many months slept and lived in his front lawn. But you see, this American hero suffered from dementia and simply thought that he unintentionally locked himself out of his home. But why did the U.S. Marshals come to take his things and kick him out of his own property? Well, because of an unpaid property tax bill of only $134. The lapse in his tax payment amassed a debt of late payments, interest, and the fees just short of $5,000. But how did it get there? When Mr. Coleman failed to pay his tax debt, the city responded by placing a lien on the debt and tacking on $183 in interest and penalties. Mr. Coleman's son attempted to settle the minor debt, but by then it was a futile attempt. A Maryland-based company had acquired the lien and intentionally inflated the debt to $5,000, a typical business model for out-of-state debt collectors. That's 37 times more than the initial tax bill, creating an intentional barrier to recovery. Mr. Coleman's son went to the courts pleading for help in his father's inability to cover such staggering and unsubstantiated debt, and expressed deep concern for his father in losing his home at such late age. A home which belonged to his father for decades and was paid in full. He managed to make a payment of $700 to assist in recovering the property, but was not able to cover the whole debt. And as such, the court sanctioned a foreclosure. The following summer, federal marshals arrived at Mr. Coleman's residence, then forcibly evicted the veteran from his property, leaving him stranded and homeless at the age of 76. But this process took more than Mr. Coleman's dignity and sanity. To collect an initial debt of $134, the convoluted and unjust system stole his entire home equity. This home's estimated market value was $197,000. That's right, the veteran and the rightful owner of the property did not receive a single cent that remained after all debts had been forcefully paid. And this is what we called home equity theft. And we will explore this subject in more detail, including the beneficiaries and victims of this predatory and morally unjust but legal practice. Let's talk about Yuri Rafali, a retired engineer in Michigan, which was faced with a similar predicament. Only in his case, all his trouble began with the simple, meager sum of $8.41. Mr. Rafali acquired a 1,500 square foot home, investing his saving of $60,000 in the property. This was a very important financial move for the retired engineer because it was part of his grander plan. Mr. Rafali intended to utilize his property as a rental to generate supplemental income for his well-deserved retirement. Despite Mr. Rafali's belief that he was constantly meeting his property tax obligations, he received a notice that he had an unpaid tax bill by $496. He swiftly rectified his situation by cutting a wholesome payment to the county. But unfortunately, something went amiss. The retired engineer miscalculated the interest, falling short by only $8.41. Why an individual would need to independently calculate interest for a debt is beyond me, but the lack of clarity on the debt owed came with significant consequences. The Oakland County, without hesitation, seized his property and proceeded to institutionally auction it off. How much did the property sell for at the auction? Well, for a modest $24,500, far below the property's worth and certainly not close to what Mr. Rafali paid for it. But even then, the county retained all surplus from the auction, collecting the debt of $8.41 and the extra $24,000. That's more than a staggering 8,000% profit. Yuri Rafali was fully able and willing to mend and resolve the situation, but was not given the opportunity to rectify it further, despite making clear initial attempts to do so. It's almost inconceivable how unfairly the justice system serves the ones in control, because in this case, law and order were not on the same page. The cost for a county to collect less than $10 in fees is much greater than such a sum. It's hard to imagine how this is not unreasonable seizure, or perhaps more clearly, theft. When faced with the receiving end of such action, it can take a toll on the homeowners and their families with heavy repercussions. That is why a battle fought by a 93-year-old Taylor is so inspiring. Geraldine Taylor, a homeowner and a grandmother in Minnesota, also found herself on the losing end of home equity theft. You see, Mrs. Taylor fell behind on her property taxes, lapsing on her tax bill for $2,300. The government, however, compounded her trouble by abandoning interest, fees, and penalties to her debt, resulting in a staggering $15,000 bill. That's no small sum, but more than 6 times larger than the initial tax bill. Unfortunately, this sum was too great for Mrs. Taylor to settle the debt, leading Hennepin County in Minnesota to seize her condo and auction it off for the total sum of $40,000. As with the prior incident with Mr. Coleman and Mr. Rafali, the governing body that took Taylor's home collected the outstanding debt of $15,000 and the entire surplus from the sale. This resulted in the county profiting an additional $25,000 at the expense of Mrs. Taylor. That didn't sit well with Mrs. Taylor, as it shouldn't with anyone, and she took the only avenue that anyone should in the situation. The 93-year-old grandma filed a lawsuit against the county. Predictably, this was the beginning of an uphill battle that would last for years. In 2020, shortly after filing the legal action, the federal district court dismissed her lawsuit, asserting that the act of property forfeiture effectively erases an owner's property interest and therefore forfeiting any equity. But Mrs. Taylor was undeterred and determined to press on. The following year, with the assistance from the Pacific Legal Foundation, she appealed the case to the 8th Circuit Court of Appeals. But once again, the appeals court affirmed the dismissal and issued a stern conclusion that she had no right to the excess cash produced by the sale of her own property to collect a debt of a lesser value. This is frustrating. It makes my blood boil. The legal system has failed her and so many other people. How can this not be a clear violation of the 5th Amendment of the United States Constitution? Taking people's property without compensation and potentially unreasonable seizure? By then, Mrs. Taylor was not far off from her 100th birthday. She said, "How much longer is this going to take? I haven't got forever." Despite the obstacles, by then the 95-year-old Taylor pressed on, but this time filed a petition to review with the U.S. Supreme Court. This was her last stand. And in January 2023, she got her wish. The Supreme Court agreed to hear her case. By now, this was not only about her lost equity, but a cause for all the victims of home equity theft. This incredible person in her late golden age, standing up to pursue justice, fighting the long battle to improve the rights of every homeowner in the country. After 5 months of argument and deliberation, on May 25th, in the case of Taylor versus Hennepin County, all 9 justices unanimously agreed that the government cannot recoup more than it's owed when settling tax debt. By seizing and selling Mrs. Taylor's home to collect a $15,000 debt, the county directly violated the takings clause of the 5th Amendment by asserting their ownership to the excess proceeds from the sale. But this is just one success story among many home equity thefts that still occur today. Despite the positive ruling by the Supreme Court, many states still abide by their legacy law, continuing to endorse and legalize home equity theft, with many of those targeted being the elderly, handicapped, and especially economically challenged homeowners. The majority of cases still don't gain legal representation and thus failed to benefit from the recent federal ruling. According to data collected by the Pacific Legal Foundation, between 2014 and 2021, home equity theft profited states and private lien holders almost $800 million. And this data was collected from only a small fraction of jurisdictions. So the actual value likely spans in the billions. And this is the issue. We have states that profit from home equity theft. That is beneficial for them to maintain the status quo. So what can you do? There are many resources online, and you will find the references to those resources in the description and comment section of this video. So please give it a read, but also share any details which you may be aware of that can help others in your state or county. If you have a story to share with a positive or negative outcome, please let us know as well. If there's anything to take away from these stories, if you fall behind on your property tax liabilities and the state comes knocking, seek legal representation, and if not too late, get help from a financial advisor, because there are options to recover from this. If you own your home, you certainly, absolutely, unequivocally have options and rights for a path to normalcy. I hope this video was helpful and inspiring in some ways, so please help this channel grow and like this video, but also please subscribe. See you next time. Bye.